Please may I go to the Upper Tribunal decision behind tab 6.
Yes.
So, where it left.
Which page is
Oh,
that?
I'm sorry, I should have said 69.
Thank you.
So where it left the FTT decision was reason 1, that the payment was a payment, a taxable payment remuneration, was that it was funding the loan, and that loan was for reward and services, for work done. Let me start again. That payment was for work done, and therefore the payment of the into the trust was also for work done. Reason 2, 56, that loan was also potentially within section 62, and that's a second reason. And this court is tasked with is to say, does that infect the inference in 57 from 56 as an error of law? So I did that point, but what it does show, and this is where the fact that we're addressing this question when we get onto the Upper Tribunal, is that, and the more I think of it, the more I should have acknowledged that the point raised by my Lord Justice Singh is a real one, is that the reason we've got into this conversation is precisely because we had CIA, we had strategic branding focusing on the proposition. A scheme that ends up with a loan at the end of it can never be taxable to earnings. And if that was the fight in the FTT, you can see why the FTT thought it was driven. It shouldn't have been. Thought it might have been driven to say, oh no, the loan could be something which is a reward. Whereas I've spent a long time since Rangers saying forget the loan. But that's
well, yes. I mean, there were loans in Rangers, weren't there?
absolutely genuine obligations. But that's the point that got traction, seemingly, in CIA and strategic branding, and that, in my respectful submission, is just wrong. And I've shown you strategic branding and CIA, where the FTT decided expressly, because there were obligations, there were no earnings. I'm not going to show you again unless you need me to, but that's what they said, and that is wrong. But that explains absolutely why this whole question of let's look at the loan, goodness me, gets traction. Now I'll get on to the Upper Tribunal, and what we find at the Upper Tribunal, just to clear what I'm going to say, and I'm not going to take long, is the Upper Tribunal said, look, the FTT did identify the correct question, that was the payment. It did do that. But it interrogated a loan, and that loan had real obligations. Go back to that again. Interrogating that loan in 33 to 37, those comments were not overturned. It looks like they might be overturned, but they weren't. And it might have made a difference to the FTT's decision. So the FTT went wrong in law. What's the right answer? The Upper Tribunal says, well, we have a world here of Mr. Currell put the money back into the company, and he was left with a loan obligation. Back to that again. And although he was under-rewarded, the obligation means that he can't, what he got can't be treated as remuneration. And I say that reasoning is bad. I say it's bad in law. It's bad logic, and it's bad in law.
Can I just go back one stage? You've just referred to the Upper Tribunal's decision based on de Gorse that in determining whether there's an error of law might have made a difference. You haven't got a ground, I don't understand your grounds of appeal to be directly challenging that reasoning.
No, because what I say is they got it wrong. And I said that this to be dealing with Grant 2. If I'm right about Rangers, even if they were right, so I'm not. This is even if I'm saying Grant 1. Grant 1 is I say the FTT got it right.
Yes. Well, I'm not sure that's necessarily the same as saying the Upper Tribunal were not entitled to do what they did, which is decide to set aside and remake. That's the question I'm asking.
And I say, if you're not with me, that the excursus say 33 to 37 is not obiter, and then I accept it might have made a difference.
So if we were to accept your, you may think this is obvious, but I just want to be very clear about it. If we were to accept your argument that passage is obiter, for want of a better expression, would you, on that basis, do you say that the Upper Tribunal was wrong?
Yes, there was no error of law. There was no error of law at all. Or an obiter error only. Yes, that's so inelegant.
Yeah. Just so we can be absolutely clear about this. And we're only dealing with Ground 1.
That's right.
For now. Okay. So the structure of the analysis is usually has the FTT erred in law? Because an appeal lies to the UT only on a point of law. If they have, then there's a second question which can arise, which is whether in its discretion the UT was entitled to set aside and decide for itself, or whether it should have set aside and remitted it. You're not interested on this appeal with those second type of questions.
Exactly right.
Yeah. What you're saying under Ground 1 is there was no error of law by the FTT, ergo the UT had no jurisdiction to be setting it aside. But what you're now about to go on to submit is that if you're wrong about Ground 1, you're right about Ground 2, and the UT has erred in law.
Yeah, that's exactly what I'm saying. Thank you, but nothing. That's exactly what I'm saying. And that's why I said this morning, Ground 2 is, say I'm wrong, and the FTT had erred in law. Then, exactly as my Lord Rochester Singh has just said, the Upper Tribunal has erred in law. And coming back now, please, to why it is I say that the Upper Tribunal itself went wrong in law. They said, 1, Mr. Currell put the money back into the company. 2, he was left with obligations. This is repeating what I was saying a minute ago, but I just want to keep it all together. 3, although he was under-rewarded, it's not like Rangers, where it was clear that salary, or otherwise would have been salary, was just bifurcated. 4, there was a real obligation in this case. And that meant it couldn't be remuneration, it being the payment. And 5, there was no side letter. And I'm saying all of those reasons, because of what I've shown you in Rangers, are bad, analytically bad. Just dealing with 1, Mr. Currell put the money back into the company. Yes, because what he was buying was access tax-free to £800,000. 2, he was left with an obligation. The Rangers employees, the footballers and the executives had obligations. 3, now this is particularly important, and it echoes a phrase, actually, that you'll see in CIA, that there was a relevant link between work, what am I in strategic branding, anyway, I can't face it again, but in one of them, there was a relevant link between the work and the payment. But that's not enough. here we have, I'm sorry to repeat it again, a clear finding that the purpose of the loan was for work done. And that was the purpose of the payment. What we'll see, the Upper Tribunal said the purpose of the payment need not be the purpose of the loan. They say that, and I say they can't say that. So that's a bad reason. And no side letter, that's an irrelevance. Remember the voluntary bonuses.
Well, did you say just a moment ago that there's a finding of fact in the present case that the payment was for MC services?
No, I said there's if you go back to my summary,
Yes.
there's an express finding that the loan was for
Yes. Yes, that's what I thought.
work done, and the
Yes.
purpose of the payment was to fund the loan.
Yes, yes. It's just that I'm looking at paragraph 128 of the Upper Tribunal judgment at page 100.
That's right. Well,
This is what the purpose of the payment was very much an issue, as I understand it, before the Upper Tribunal.
well, you're saying it's not remuneration. So
Yes. No, remuneration for MC services.
yes, right. And I'm saying that there might be fighting about it, but it shouldn't be a fight, because if the loan was for work done and the payment was to fund the loan, what else is the payment for? That's
Yeah. I
that's
can
what-
understand that as a matter of legal submission.
Yeah.
You're entitled to make that submission, and I understand it. But all I'm saying is that at least for the respondent side and the Upper Tribunal, I think, didn't understand the FTT to have made a finding of fact to that effect.
Well, can I deal with that when I get to this? Because
Of course.
and I'll get to it when I get to paragraph 130 and 131.
Yes.
Because I have done not just to death, and beyond, about how it is that the purpose of the loan was for work done.
Yes.
The purpose of the payment was to fund the loan. The purpose of the payment must be the purpose of the loan. The company knew that was the case. There is no way to drive a wedge between the purpose of the loan and the purpose of the payment. And that is as much an inference of fact as it is as an analysis of law. No other inference is reasonable. So I get it that the respondent say the payment wasn't remuneration. You're going to say that. The question is why, and that's the reasons given by the Upper Tribunal. I say are wrong. Now,
I take it that what you've given us is your quick summary and you're coming
Yes.
back to it in more detail.
oh yes, I'm going to do that now.
Thank you.
Please can I start at page 71. Because here, the Upper Tribunal, as I did this morning, they're setting out the statutory landscape, section 6, section 7. I didn't show you section 7, but it doesn't add much. And then goes to section 62. But I showed you section 9, section 10, and then critically section 15 and section 18. Receives means payment. And that does alter the juristic intuition of how this stuff is supposed to work. And you'll see a paragraph, as it happens, at paragraph 9. The Upper Tribunal mentions section 15, but not 18. Please can I go to paragraph 29, page 74. So here they're looking at what the FTT did. And just as my Lady Justice Falk pointed out, it said it would use the expression reward or benefit as meaning the section 62 reward or benefit. And I've addressed you on why that can be sloppy, but we hold that thought. They set out the issue. They got that right. The FTT told us what its focus was. They got that right. Now, little 4, this addresses the very point we were discussing just before I opened up the Upper Tribunal decision. The substantial reason, this is what the FTT said, for the appellant making the payment was to enable the trustee to make the loan. The FTT also said, and the Upper Tribunal records this, a real loan can be a reward or benefit, and here the loan was a reward or benefit, bearing in mind nobody is saying there are 2 tax charges. 6, the only reason, and again important, because the other 2 reasons, the asset protection and the bonus pool, they've gone. So the only reason for making this loan, if you're the trustee, is for work done. And what is true and here the FTT did not make this connection, is that must be the only reason for the payment. It's not asset protection. And it's not creating a bonus pool. It was to make the loan. And then they set out 56 and 57. See. Then at 30, we've got this slight distraction about whether it's only 62.2b which is in play. The answer is no. And then at paragraph 35, page 76, you've got the tribunal setting out these paragraphs which I say have caused all the trouble, 33 to 37. And then at 37, on page 78, they say in his written submissions, Mr. Elliott to describe the FTT as having concluded that the transactions gave rise to earnings on the ground that the loan conferred a benefit on Mr. Currell, and the amount of the taxable earnings was the amount of the principal of the loan. No, that's not what 57 says. It says the payment was the earnings. That is a mischaracterization on any view of what the first year tribunal had found, on any view. It never said that. Moving on to 41. Mr. Elliott accepted the FTT had set out the issue correctly. That's what I mean, and the UT is not quarrelling with that. But then at 42, what the appellants are saying is that the FTT shifted and asked itself a different question. Well, that's true. That is a different question. Could this loan be earnings? And everything that the appellants submit at 42 on its terms is right. The revenue don't argue with that at all. What the FTT did at 33 to 37 is ask whether a loan could be a gratuity, but I'll take that back, a reward or benefit.
Sorry, you're talking about 42.
Yes, exactly right. So I accept that at 33 to 37, and I have to accept it, it's obvious, that what was being interrogated at 33 to 37 by the FTT was whether a loan could be a reward or benefit, and potentially within section 62. But I said that this morning. What they didn't decide was that the principle of the loan was the taxable earnings. They didn't do that. Moving on, please, to page 89, paragraph 82, just for the record, everybody accepts that NIC should follow PAYE. But at 84, it's a repetition. The FTT had identified the issue at 14, it was picked up by my Lord Justice Singh this morning, that they put short the relevant issue was the payment. Please may you look at 85 on page 90. That first sentence is key, it's critical. So it's quite wrong to suggest that the principle of the loan was the subject matter of the FTT's decision. And we've seen paragraph 57 of the FTT, you can't say that. And at 86, they agreed with Mr. Waldegrave that the FTT decided that the payment comprised earnings with section 62.2 generally, not any particular limb. We've got to find a limb. I say it's A or C. They say, if I can take this short, that the discussion about 62.2b as being very important is being difficult to explain. I don't accept that. What any discussion of section 62 and the ambit of what counts as employment earnings has to acknowledge is that it's a wide ambit. That's what my Lord Hodge said in Rangers Supreme Court. And that even includes money from somewhere else, like a tip. And what's more, coming from somewhere not the employer. Now here's 87. This is now exposing the fight. The appellant's ground of appeal is based on the FTT having made an error of law when it held that a genuine loan of money with real repayment obligations can comprise earnings. I say that observation is irrelevant. They're saying it makes all the difference. So that's why I'm saying that the exchange we had this morning was helpful, because it shows that what I was saying was right, and that's what the Upper Tribunal thought. Did that excursus amount to an error of law that infects the decision? At 90, page 91, and I'm just going to trail this because it's really our ground 3. You've got the appellant making these submissions. Look, you've got all sorts of provisions that tax employment-related loans. Why are we even looking at a world in which a loan is taxable? And decide to follow. And that's the point. We're not talking about the loan. We've already shifted our eyes, our gaze away from the loan. So, the payment. You end up with a loan. And that's why we, this gives then an explanation. If you look at what the Upper Tribunal is doing, let's start at paragraph, please, 94 on page 92. It's looking at money. And at paragraph 94, 95, the focus was on the loan. It only received a loan. And then say, well, it all changed in the division and then in the Supreme Court. And that was a new point. Well, maybe it was. But at 98, they say that wages doesn't help the revenue in this case. And you can see how, with the directive of travel by the Upper Tribunal, because if you look at what they say, sorry to read this out, but it's important. Although we do recognise, this is paragraph 98, that the Supreme Court's decision on this issue was made in the context of a trust arrangement where the funds were then lent to the employees, i.e. the fact that the employees received the loan and nothing more in Rangers, albeit one that was not expected to be repaid at term but would be renewed and repayable out of the estate on death, did not on the fact prevent the payment to the trust being found to be earnings. Well, that's quite compressed. I was saying the payment to the EBT was earnings, which the employees were happy about. Don't get involved in whether the obligations were genuine on the loan. And so they say at 99, and they're having this fight now, which is, again, the unnecessary fight. They're saying, we don't think a loan can ever be earnings looked at in isolation. That's what they're saying. At 99, right through to 100, to 101.
Can I just ask you about the first sentence of 100,
Yes, my lord.
where they attribute to your junior, who was then appearing for the revenue, that he sought to characterise the issue of whether the making of a loan constitutes a payment of earnings as being fact sensitive.
Yes, my lord, because what the... sorry, I do need to...
No. Is that the way it was put for the revenue before the Upper Tribunal? Or have they got that wrong?
No. Yes and no, but I'll explain, and it's
Right.
very straightforward.
Okay.
The revenue said, look, it's the payment we want to tax, not the loan. But given that the FTT have gone on and on and on about the loan, I paraphrase and I'm being polite.
Yes.
Given the revenue have gone on and on and on about the loan, and given that that's what you, the Upper Tribunal, are focusing on, actually we think if that's a point for us, we will address that. The loan can be earnings. Right. It was an utterly straightforward and correct response to the FTT decision.
And that's your ground 3 as well.
That's right, exactly.
So you
Exactly.
still maintain that
In the alternative.
in the alternative.
Yes, I do. And I don't want to take up too much time. Let me be clear, I'm not going to waste court time on a point that I think is bad. I say that a loan can be earnings, Mr. Waldegrave will address you on that, and Tuftley says exactly that. But anyway, I'm not talking about Tuftley's right now, I'm talking
No.
about this. And this is where they've engaged in this point that's got traction, that nobody should be engaged in. Can a loan be earnings? Can a loan not be earnings? You don't need it for this case. It's Rangers. It's the payment into the trust, which the employee is cool about because it will be lent. Don't we think the loan's irrelevant to the commercial background?
Well, it sounds though the Upper Tribunal were required to engage with it because it was raised.
I can't hear you.
It sounds as though the Upper Tribunal were required to engage with it because it was raised before them and it's being raised in this court.
Well,
So it's difficult to say it's irrelevant. We understand that it's in the alternative.
no, my lady, I do say it's irrelevant. What I'm saying is this. It was raised, and to that extent the FTT brought it on itself, that it's discussed this proposition that whether a loan can be earnings. That's because the FTT elsewhere had said, no, it never can be earnings. So, while I don't blame the Upper Tribunal for engaging with it, one, and in my respectful submission, approach and the correct approach might be, that's a question for another day. What I want to know is whether the payment was earnings. And that's what most appellate courts do. They say, well, there are other questions that may need to be answered on another day, but here all we care about is whether the payment is earnings. We don't need to engage in this exercise of whether the loan can be earnings or was earnings.
Just at this stage, the Upper Tribunal are responding, as I understand it, to HMRC submissions in support of 33 to 37 of the decision. That's what 99 says.
That's true, my lady, but the primary position was still that the payment's earnings.
Okay.
And this case could be, and in my respectful submission, should be decided on that primary basis.
We have that.
And that's all I want to say about this. This is me saying none of us need to have this conversation, and not even before the Upper Tribunal. Could have said there's all this stuff about whether loans can be earnings or not. We don't need to go there. Even if it was argued before us, we don't need that point to decide that point, to decide this case. But as I say, nobody who cares what I think, they did. And what I am saying, though, is this is illustrative of this point, that this point has got traction. This seems to be the important point, not whether the payment's earnings, but whether if you end up with a loan, that arrangement can ever be earnings. And at paragraph 104 at page 95, they say, well, that's an error of law, because loans, if you end up with a loan, it can't be earnings, and it might have made a difference. And although Mr. Waldegrave is right that it looks auditor, we don't think it is. Why? At 108, and I'm not taking a point from this, as my Lord Rochester Singh has addressed. On the second question, if there was an error of law, are they entitled to exercise their discretion? I'm saying, on ground one, that none of this is an error of law at all. You got that one. But this is why the Upper Tribunal said there was an error of law and it might have made a difference, and it wasn't overture. This is the point, it's not overture. Why? The FTT thought it was necessary to consider the issue in these terms, whether a genuinely repayable loan can be a reward or benefit. So why are they even asking that if it's overture? That's what the Upper Tribunal is saying. 2. And in answering that question, they were looking at the loan. That's true. 3. The FTT was discussing this question about whether a loan can ever be earnings. And 4, one of the things, this is exactly what we were discussing just before lunch and just after lunch. One of the reasons the FTT said the payment was earnings is because the loan was earnings. And that can't be right. This is the place to plug in. They didn't decide the loan was Section 62 earnings because we haven't got 2 tax charges. But anyway. And then they said, and what's more, we discussed all these cases like strategic branding or CIA, and that shows that what they were considering was whether a loan can be earnings. So none of this is overture. Now, importantly, they remade the decision, as you know. At 115, they addressed the money flows. I'm not going to pause there because I say respectfully, nobody understands the money flows. 116, they refused to disturb the findings of fact. So that's primary facts and inferences. It's at page 98. And at 117, it means that we're looking at undisturbed findings of fact and inferences. So then at 120, they say, well, we're going to look at, and ask whether the payment was earnings. So it's the same issue as the FTT were discussing, the right issue. They summarize ranges, and at paragraph 124 at page 99 of little 3, you'll see that they acknowledge the record. Lord Hodge saying that the employees, meaning the executives, had no contractual entitlement to the bonuses. But then you look at 127. 126. The decision of the Supreme Court in Ranges establishes that a payment to a trust or another third party may itself comprise taxable earnings in that amount. It is not precluded from being such by the fact that the employee receives such amount from the trust by way of loan rather than outright gift. Now, pausing there, that's not the archaeology of ranges. The archaeology of ranges is that the payment to the trust is for work done, which for whatever reason the employee is happy with. So the introduction of the loan as part of the ratio of ranges is wrong. And then she says, they say, I beg your pardon, I'm very sorry. It was accepted by the taxpayers that the payments to the trust were remuneration for services provided with the employees, including the footballers and the executives. Well, yes, and here we say this isn't agreed, but we say we've got the point. If the loan was for the work done, the payment was for the work done. Then it's 127. The role then played by whether there was an entitlement to the relevant remuneration is more difficult. No, it's irrelevant. Lord Hort set out the issue at 1 as involving the circumstance that the employee had no prior entitlement to receive it himself or herself. Then set out the general rule as being that the charge to tax extends to money that the employee is entitled to have paid as his or her remuneration, whether it is paid to the employee or third party. No, that does not capture the discretionary voluntary bonuses. Here, as Lord Hodge was rejecting the Taxpayers' Council submission that a payment to a third party can only be earnings if the employee had a legal right to receive the payment. No, not for the voluntary bonuses. And it was paid at his direction to a third party. Facts then involved two different situations. For the footballers, the focus of the discussion before the engagement was on the net remuneration made available put short because of the side letter. There was thus a contract providing for the amount to be paid by Rangers to the Trust. There was no equivalent to this side letter for the executives. For those employees, Lord Hort said, there was no contractual entitlement to the bonuses before their employer decided to give them. We agree with Mr. Elliott's submission that this should not be read as saying there was never an entitlement at all. Where did they get that from? That's not in Rangers. Rather, remember the gentleman who decided his own bonus. Rather, there was no entitlement to these bonuses which had been agreed upon engagement. But during the employment, the employer decided to award the bonus and decided this would be delivered through the trust arrangements. Now, if you unpack that, the tribunal's either saying they're accepting a submission that needs to be some sort of prior entitlement or not. But this phrase, we agree with Mr. Elliott's submission, they should be not as read as never was an entitlement at all. That must be wrong for a voluntary bonus.
Well, they seem to be accepting it. And so if the submission is wrong, you submit the UT has fallen into error.
Well, of course it has. I'm not saying agreeing with Mr. Elliott is necessarily an error of law. I'm just saying that this submission...
No, agreeing with that submission
is
if we just unpack it, and it may come back to a point my Lord raised this morning, that would you accept the following analysis? I'm not saying you should, but I'm just trying to understand what they're saying. Could it be the law that although when an employee starts work, I think that's what they mean by upon engagement, sort of footballer or the manager, whatever it is, they start work for the employer. At that point, there is no entitlement to a bonus. It's discretionary. But can it be that as a matter of law, at some point, the position changes? Once the employer has decided to exercise its discretion to make a bonus payment, that somehow there is an entitlement to be paid at that point. Is that the right way of looking at it?
Well, it might be. Well, how does that fit into the Rangers discussion? Imagine this bonus. Please don't go. I'm going to pay you a fucking big bonus. Please don't go. But by the way, because we've been sold this scheme, I'm not going to pay it to you. I'm going to pay it to the trust. That kind of scintilla temporis kind of entitlement is not a real world prior entitlement. That should make any difference, that will all the difference in Rangers.
It would only work if there was some engagement with the employee before the decision was taken. If management simply sat around a table and said, we're going to pay this amount into the trust for these employees with no interaction with the employees at all, quite hard. I'm struggling to find where you find, even after the bonus has been declared, the entitlement.
I respectfully agree. And remember, Mr. Black has decided his own bonus. It just gets madder and madder. This submission's wrong.
Yes, although I think you do, I mean, Rangers is not straightforward in this respect because the position of the executives is dealt with so shortly. And I think, respectfully, the Upper Tribunal earlier in this paragraph are picking up an earlier statement in Lord Hodges' judgment that doesn't translate very straightforwardly to the position of the executives with their bonuses.
Which one was it?
They refer to it at 41.
If you show me, because I
Well, I haven't gone back, but that's my reading of it.
oops, because I showed you paragraph 39 of the Supreme Court where it talked about
Yeah.
entitlement. That was all through the footballers.
So they're citing from paragraph 41 of Rangers, page 920.
Page 920. Sorry.
Page 920 of the authorities bundle.
Oh, sorry. Okay.
That's what the Upper Tribunal is citing from. I'm simply making the point that some of those earlier comments by Lord Hodge do use language of entitlement. And it isn't, speaking for myself, entirely straightforward to translate those to the position of the executive bonuses. Now, you obviously quarrel with the way that the Upper Tribunal sought to do that at the end of the paragraph.
Yes, my lady, I do. And I showed you not only 41 but 39 this morning, which used that word entitlement. I went out of my way to do that,
Yes.
to show you that when he was talking, because he's bleeding from the footballers into the executives, there was an entitlement to have that in the side letter to say, you've got to pay that money into the company. And so while it's an excellent judgment, he could have made it even better by saying, by the way, the word entitlement isn't an apt thing to do when I'm talking about voluntary bonuses in the context of executives. See what he
Yes.
said at paragraph 31,
Yes.
and then at 66, and he goes out of his way to say voluntary bonuses.
Elsewhere, he uses this concept of arranged or acquiesced,
Yeah, and
which may be a less controversial
I think that's right,
way
my
of
lady.
putting it, and actually maybe it's relevant to the point my lord just made about directors sitting around a table and never telling the employee.
All that, or deciding my own bonus. So, my respectful response is I don't accept there's any trouble with that applying ranges to the executives at all. I don't accept that. There were voluntary bonuses. He knows they're voluntary. He knows there's no contractual entitlement. He says so. You've got one guy, one person who's choosing his own bonus. So you've got all that. This proposition is therefore wrong at 127. It can't stand with the decision on the voluntary bonuses of the executives. It's impossible. And the word entitlement, when used in not just 41 but 39, which I showed you, is either properly confined to the footballers or is viewed as something like some sort of moral right or something of that nature, but it's not a statute. Please can I show you, because I must leave time for Mr. Watergrave.
Yes.
Please can I show you 130 and 131. So we've got this fight, it's not remuneration at all. And I say it's got to be. It's funding a payment that's made for services, and that's the only reason left. It's got to be. And at 130, what we've got is, we agree with Mr. Waldegrave, artificial to focus only on the finding made by the FTT as a substantial reason for the payment, rather than going on to take the point that the subsequent finding is the reason for making the loan. So you've got to look at everything. And they say it's all pre-wired. Now this sentence, however, we conclude that these findings do not support the conclusion that the payment itself was money paid as a reward or remuneration. How can they say that? The only reason for the loan was work. And the company knew, you've got it in the summary of facts, the company knew that. And he says, the tribunal goes on to say they consider the full picture as part of an arrangement that would go back to the company. That's the scheme. He's bought himself access to 800,000.
Does the entitlement point that you say is wrong at the last sentence of 127 actually feed into any of the analysis that they do?
No, it
I don't
doesn't.
want to have, we've got obiter and obiter at both levels of this, but it does appear to be obiter.
It comes back. I'll show you. And then at 2, we've got this obligation again. He buys these shares, but he's got this obligation. No expectation that the loan wouldn't be repaid. Well, that's not true of Rangers. It was on the estate. That's true. Would be renewed only ultimately after this. They are acknowledging Rangers because the expectation was that the loan would be repayable, but only on death. We recognise that Mrs. Currell and Mr. Currell had acted together in building up the business, and there was no reason why he had misgivings. So that's the unaffected access point. And he was under-rewarded to say that too. But they say at 3, he didn't have an entitlement to a salary. Well, that's just saying, I didn't have an entitlement to a salary. The question is, what was the purpose of the payment? None of these reasons stack up. I'll be clear, none of these reasons are good reasons to treat the payment as anything other than for reward and services. So they're wrong to say Mount Speckel submission at 130 that the payment was not paid as a reward. Now they say it's clear at 131 that the FTT considered there to be a link or connection between the payment and directors. So that's the, and do you remember I showed you the relevant link to work in the other cases, CIA and strategic branding. You got that here. It's more than a relevant link. So far as the loan's concerned, it's the only connection. So that's an unfair dilution of the purpose of the loan and payment looked at together. More than a link. It's the only driver, the only reason. And here to say the appellant knew that 800,000 would be lent, and this occurred. But the existence of such a link or connection is not sufficient. Why not? When it's the only reason. Takes no account of the character of what he received. What the 8 he received was the payment into the trust, which was then lent that made him happy. And whether it was a Rangers loan that's repayable on death, or even if it was a loan that he would have thought he might have to pay back in 5 years, that doesn't change anything. They found in terms, as have to, there's a link between the directorship and the loan. But they say that doesn't mean the payments for that. Because of what? The obligation. It's that focus again on this point that I say has got traction at tribunal level. And they say key difference between this case and Rangers, not only the agreement between the parties that there was being remuneration being paid, well that's not a reason. But the facts in relation to the side letters, who cares about the side letters? Who doesn't really? Who needs a side letter when you control the company with your wife? And the executives didn't have side letters, as it happens, and they don't mention that. No mention whatsoever of the voluntary nature of the payment. They've recorded it, but the kernel of the reasoning is in 130 and 131. And that's it. And so if you ask yourself, my Lord asked me, does this entitlement come back? It comes back right at the end when you look at the side letter as a point of distinction from Rangers, with no explanation. as to why that matters. And that's why I do respond, as I did to my lady just to start, to say I don't find applying ranges to the executives difficult at all. Don't need and this reasoning of the Upper Tribunal has no respect for the ratio ranges for the voluntary payments and the discretionary bonuses. It makes a point about the side letters. Having said the factual findings are undisturbed, they call the connection between the loan and the directorship a link. What does that mean? It was for the services, and therefore that's the payment of the loan. But say that's not right in paragraph 130. Why not? So the errors of law are the misapplication of ranges, the need for a side letter, looking at the obligation created by the loan, and the quite literally ignoring the fact that the only reason for the loan, which was funded by the payment, which is what we're talking about, was what? That's my ground too. Even if they were right that the excursus by the FTT is an error of law, the UT went wrong. Disposal, before I hand over to Mr. Waldegrave. Disposal, if I'm right about ground one, then my respectful submission is that this court can allow, and please may the court allow the appeal and restore the decision of the FTT. If you think the FTT went wrong, then my respectful submission is that the Upper Tribunal's analysis at 130, 130 and 131 can't stand. So it's for this court to remake the decision. You've got plenty of material. And there's only one decision that my respectful submission the court can make. The loan was for work, the payment was to fund the loan, the payment was for work. That's it. This is just ranges. And that is preferable to allowing the appeal and limiting it. Those are my submissions of ground one and ground two. Please may Mr. Waldegrave follow on ground stream 4.
Yes, thank you.
He's going to, I invited him, but he wants to stay there.
Yes, thank you.
Good afternoon, I propose to address the court first on ground 4 and then on ground 3. And I'll take the grounds in that order because ground 4 goes to the question of whether the payment is earnings, whereas ground 3 is the alternative case, loan is earnings. Obviously, grounds 1 and 2, which Mr. Ghosh has been focusing on, concern the question of whether the payment is earnings.
I think you're going to have to speak up a bit.
I'm sorry, my lady. Do the microphones make a difference? I
No,
think I can.
they're just there to record.
I think I can. I'll just speak up.
Yeah.
I'm sorry. So under ground 4, we say that even if the UT was right about what it said about entitlement and ranges in relation to the need for some kind of entitlement in order for the payment to be earnings, it went wrong in applying the relevant principles to the facts of this case. And this is because, despite saying at paragraph 117 that it was respecting the FTT's findings, stated in relation to one minor and controversial point, it didn't in fact do so. And critically, the Upper Tribunal did not respect the FTT's findings in relation to 2 matters. These have been mentioned by Mr. Ghosh, so I can deal with this quickly, but I do just want to put points. The first matter concerns the nature of what Mr. Currell actually got. And my submission will be that the FTT found that, viewing the facts realistically, Mr. Currell, this money was simply made available to Mr. Currell. The UT took a different view and erred in doing so. And the second critical respect in which the Upper Tribunal did not respect the FTT's findings relate to the nature of the relationship between the payment or loan and Mr. Currell's work in the company. and my submission will be that the FTT found that the reason for the payment in conjunction with the loan was Mr. Currell's work for the company. And the Upper Tribunal was wrong to downgrade that to a link or connection. I'm going to structure my submissions on ground 4 as follows. First, I want to identify the 4 key building blocks of the Upper Tribunal's decision that the payment was not of Mr. Currell's earnings, and then look at each of them in turn. And I do accept that there is some overlap with the submissions that Mr. Ghosh has just made, so I will try to do this as quickly as possible. So the analysis underpinning the Upper Tribunal's remaking of the decision is, as you've just seen, at 130 and 131. Those are the key paragraphs. I've identified 4 key building blocks in those paragraphs. I think Mr. Ghosh might have mentioned 5, but I think we're essentially saying the same thing. So, first, in contrast to the situation in Rangers, the Upper Tribunal thought that Mr. Currell had no entitlement to the 800,000. So that was important point 1, and you see that in subparagraph 3 of 130. And it also features in 131, where there's a reference to the side letters. 4, 3 lines up from the bottom. The second key building block in the Upper Tribunal's analysis is that in Rangers it was agreed that the payment to the EBT was remuneration, whereas there was no agreement in this case that the payment was Mr. Currell's remuneration. And we see that in 131 in the bit where they say we have identified the areas of key difference with the facts of Rangers, and the first thing they mention is the lack of agreement in this case as to whether the payment was remuneration. The third key building block of the Upper Tribunal's decision is that ultimately what Mr. Currell got was a loan which was subject to a real repayment obligation, and in contrast to the position in Rangers, there was no expectation that the term would be extended until death. So we see that in subparagraph 2 of 130, and we also see it in 131. There are, I think, in a couple of places in 131 references to what Mr. Currell got being the loan. And the fourth key building block of the Upper Tribunal's analysis was that although there was a link or connection between the payment and Mr. Currell's work as a director of the company, this was not sufficient in light of what Mr. Currell got being the loan subject to an obligation to repay. And you see that in 131. So those are the key elements in the Upper Tribunal's analysis. I want to look at them one by one. So the first point is entitlement. Mr. Ghosh has made detailed submissions on that in relation to ground 2. Now, the position on this, I think, is as follows. If we're right on ground 2, and entitlement is not relevant, then that removes a key pillar of the Upper Tribunal's reasoning. But obviously we need to look at the other factors that they relied on to assess whether the payment was of earnings. If we lose on ground 2, so entitlement is relevant, then we still need to look at the other matters which the Upper Tribunal considered in these paragraphs. because on its own terms, the Upper Tribunal clearly thought that lack of entitlement wasn't the end of the story, because if it was, it wouldn't have needed to make these points about the nature of the loan and so on. And so in that respect, even if we're wrong on ground 2, we could still succeed overall by reference to ground 4. That's what I wanted to say about entitlement. Second, the lack of agreement in this case that the payment was Mr. Currell's remuneration. So the Upper Tribunal attached importance to the fact that in Rangers it was agreed that the payment to the EBT was remuneration, whereas there was no such agreement in that case, in this case. Now, of course, it's right in this case that there is debate as to whether the 800,000 was Mr. Currell's remuneration. And so in that sense, in this case, the tribunals needed to decide a point which wasn't an issue in Rangers. So there is a point of distinction between this case and Rangers in that sense. But the question that the fact that the tribunals in this case needed to ask whether the money was remuneration in a way that they didn't in Rangers doesn't tell you what the answer to that question is.
It might reduce the force that Rangers might otherwise have in directing an answer on the facts of this case.
Absolutely, my lord. I accept that if it was common ground in this case that the 800,000 was going into the trust was remuneration, well, it's difficult to see how we would be in litigation at all about this. It would just be Rangers 100%. So I absolutely accept that point. So we say that the Upper Tribunal was wrong to attach significance to the fact that in Rangers it was agreed or it was obvious that there was remuneration. It just means that the tribunals in this case needed to answer the question. It doesn't tell you what the answer to that question is. Third, the loan. So the Upper Tribunal clearly attached importance to the fact that ultimately what Mr. Currell got was a loan which was subject to a real repayment obligation, and it thought that there was a contrast which could be drawn with Rangers in this case. So in relation to this, we make the following criticisms. The first point is that the question which the Upper Tribunal was looking at here was whether the payment was earnings. It wasn't considering whether the loan was earnings. Now, I accept, as Mr. Ghosh said, that one can of course interrogate what happened subsequently. You can look at the loan, the nature of the loan, to shed light, to help learn about the nature of the payment going into the EBT in the first place. So it's possible that what the Upper Tribunal was doing was looking at what happened to the money after the payment was made to see if that could cast light on the nature of the payment. We accept that that could be a legitimate, is absolutely a legitimate exercise. I would just note, though, that that doesn't seem to be what the Upper Tribunal said that it was doing. But suppose that is what it was doing. We say that the tribunal, the Upper Tribunal, was wrong to draw the contrast it did between the loan in this case and the loans in Rangers. So at paragraph 101 of the Upper Tribunal, at the end of that paragraph, The tribunal said that the money lent to Mr. Currell was not placed unreservedly at his disposal.
So are you 101?
Yes, paragraph 1, final sentence. The money lent to him was not placed unreservedly at his disposal. And this comment was made in a part of the decision where the Upper Tribunal was assessing whether there was an error of law on the FTT decision. So this wasn't part of its remaking analysis. But it seems that this view of the loan did inform its analysis in paragraphs 130 and 131. And we say that the view that the Upper Tribunal took of the loan does not properly respect the FTT's findings in relation to it. And does not properly respect the degree of control which Mr. Currell in fact had over the loan based on the FTT's findings. The key findings which we rely on in relation to this are set out in the note which we handed up at the beginning. I'll just highlight a few points. So the FTT found that the funds could be withdrawn from Mrs. Currell's loan account with the company and used as Mr. Currell wished, there being no fetter on such use. Paragraph 36(13) of the FTT. There's the finding at paragraph 50 that Mrs. Currell could be expected to act for the mutual benefit of both of them.
And I wonder whether we're comparing like with like here, though. Anyone who draws down on a loan, pays it into their own bank account, has unfettered access to the credit balance that it represents. The Tribunal at 101 are not concerning themselves so much with what you do with a loan when you've got it, but the fact that there is an obligation to repay it, and contrasting that with unfettered access to money in the sense of it's yours without a corresponding debt obligation.
Yes, my lord. The submission that I would make is that, viewed fairly, what the FTT actually found was that Mr. Currell had very great control over whether this money would ever be repaid.
Well, not quite the terms in which they put it.
They don't.
In fact, well, we can read it for ourselves.
No, absolutely. They don't explicitly make finding in those terms. But what they do say is that the trustee is reactive. So the power of instigation lies with the company. And we know that Mr. Currell is a driving force in relation to the company. And we know that Mrs. Currell is acting with him for their mutual benefit. So I accept that there is no explicit finding of fact that Mr. Currell simply has an option as to whether he's going to repay this loan. You have to find it in a few different places, but we say that those findings, which we've set out in that note, do give one enough to say that if you're engaging in an exercise of comparing the nature of the loans in this case, with the nature of the loans in arrangements, there's no meaningful distinction, or at least that the FTT was entitled to take the view that it did. It's also important in this regard to remember that the FTT rejected the company's case as to the rationale for this scheme two reasons were put forward. One, this is to create a bonus pool. Two, it's to ring fence assets. FTT rejected both of those. And then there's the point about double taxation. Mr. Bush has discussed that. So on any view, Mr. Currell had unfettered access, true unfettered access, not just in the sense that just mentioned, but true unfettered access for the first 5 years, because in that period, the trustee could not get the money back. And so, in a sense, you could just, if focusing just on that, as Mr. Ghosh said, you could regard that as a bridging loan and say that could be enough. But on a fair view of the FTT's findings, they actually go further than that. Even after that 5-year period. The position is that
Presumably you would accept that in principle, well, let's move right away from this case, this sort of case. No third parties, no trusts. Just in an employment relationship, presumably you can have a situation where the employer gives a loan to the employee. And that doesn't count as part of their earnings.
Of course.
Season ticket loans.
Yeah, exactly.
Yes, absolutely, my lord. And Mr. Elliott has referred to the various provisions which deal with the taxation of loans. And of course, those would all be pointless if it was the case that every single loan from an employer to an employee was
So the mere fact that there is a loan, which obviously, however one wants to put it, it's of value, it has financial worth, it's a benefit, if you like, and the fact that it's linked to a person's employment, those things taken together don't mean that it becomes earnings.
Absolutely right. That's absolutely right. I think we're probably stepping into ground 3 here because we're now focusing purely on the loan, whereas under grounds 1, 2, and 4, we're looking at the payment and.
Forgive me, yes.
I think this brings out something that was in Mr. Ghosh's submissions as well, which is that if the sum of money is paid into the Employee Benefits Trust that advances season ticket loans to the employees, for my part at least, I find difficulty that structuring a loan turns what was perhaps a taxable benefit in the form of an advantageous loan into remuneration in the form of payment at the level of the employer and the EBT. Just sounds counterintuitive.
Yes, I mean, in those circumstances, ultimately, there's the factual question that you have to ask: is the payment that you're looking at, is that a payment of the employee's remuneration?
Equally, I can see that if you had someone who was the protector of the trust who was able to control the trustees and effectively ensure the loan was never called in or extended for a lengthy period, one would be having a very different conversation. We don't have that sort of those facts here, do we?
Well, we don't have the facts in the sense that Mr. Currell's a protector of the trust or anything, but we do have findings that the trustee is reactive. It's going to react to the company's proposals, and Mr. Currell is a driving force in relation to the company. And so, as Mr. Ghosh said earlier, okay, in this case we don't have the subtrusts and protector of subtrust type facts, but we don't need them because it's a small company, and Mr. Currell is effectively in control of, in conjunction with Mrs. Currell, he's in control of the whole thing.
Just to put some flesh on that bone, you're saying by using his control of the company never to suggest the awarding of any bonus to any other employee. With a reactive trustee, there is the mechanism there to ensure the loan is called in.
Yes, because why would the trustee do it? The only other thing it can do with the money is pay bonuses to other people. In fact, we know from the FTT decision, Mr. Ghosh showed you this, that the company has been carrying on its ordinary practice of paying bonuses in a perfectly conventional way, not using EBT. those are the main points that I wanted to make in relation to the findings that the FTT reached on the loan. The Upper Tribunal was impressed with a contrast between the loan in this case, which it said had this sort of real repayment obligation, and the loans in ranges. And we say that contrast doesn't work. In ranges, there were also real loans. They had a real repayment obligation. Okay, there was an expectation that they were going to be, the 10-year repayment term was going to be extended. We don't have an explicit finding in this case that there was such an expectation. It doesn't matter because we have these other findings which we rely on.
Sorry, what other finding?
Well, the findings to do with the degree of control that Mr.
Oh, I
Currell
see.
had.
Yes, I see.
I'm sorry.
Maybe one way of looking at the distinction with ranges is this. In ranges, by the time we got to the Supreme Court, it was common ground that the payments into the trust were remuneration, and the question was whether payments directed in that way could be taxable as earnings. Really, the loans made out of the subtrusts, arguably neither here nor there. The focus was on the payments. Here, you can't say the loans are neither here nor there because, as Mr. Ghosh has explained before you stood up, you're relying on the FTT's finding that the loan was, I think he said, for work. And then you're saying, well, because the payment was just to fund the loan, that means that the payment has that character as well. So this is different to ranges. The loan is actually central to your arguments.
The loan is important in this case because we have a debate about a point of fact which didn't arise in ranges. So in ranges there was agreement that there was remuneration. In this case there is no such agreement. So we need to find clues which help us work out whether the payment is remuneration. And some of those clues, we say, can be found in the nature of what happened to the money after it went into the EBT. So what happened downstream, as it were, can inform us, can educate us about the nature of the payment going in. So in that sense, I accept my lady's point that the loan here and everything that happened after the payment went into the trust is important evidentially because it casts light on, or it might cast light on the question of whether the money going in is remuneration. That wasn't a question which needed to be grappled with in ranges, it is in this case.
Okay.
So I absolutely accept that the loan is important evidentially in that way. But analytically, the position is exactly the same as in ranges. If we're right that the payment going into the trust is earnings, that's that. Mr. Currell gets a loan and buys shares with it. He might have bought a yacht. It doesn't matter, analytically.
Have you finished your 4 points?
I think, my lord, I have.
Right,
Yes.
very good. Well, if you were about to move on, can I ask you about something we haven't so far touched on, but it may be relevant? It's the last sentence of paragraph 130 of the Upper Tribunal judgment. It's subparagraph 3. This again seems to be something that they focus on as being a factual point of contrast with ranges, where they say that case did focus on the net remuneration that would be made available to the footballers. And they say that here they draw a contrast with the findings of fact made by the FTT. The appellant would not have been paid this amount as remuneration. Is that
Well, I think this is partly the entitlement point.
Well, I'm not sure. I mean, the first sentence of that subparagraph is certainly an entitlement point, but I think it's going beyond that. That it's, if you like, that. All right, you say he was under rewarded, but what if you have a situation where someone is massively over rewarded? Does that give you some insight into what the nature of the payment is? If it's not basically substitute for what he would otherwise be paid. Now they may not be right about this, but I do read their reasoning as placing some weight on this factual point of contrast. Now you may say they're wrong, fine, but am I right to understand that this is part of their reasoning?
Well, my lord, maybe I can say this. If the practice of this company had been to pay Mr. Currell a bonus of 800,000 every year,
Yes.
and if in this year they said, okay, no bonus, but we're going to do this,
Right.
we're going to put money into the scheme. In the FTT, I would absolutely have fastened on that factual feature.
I'm sure you would.
Would have made much of it. But the lack of that fact pattern doesn't mean that this was not earnings.
I see.
Of course, it would be a helpful point for us if it could be said.
Forgive me for interrupting you, but you may tell me that I'm missing something important here, but this may be, at least to my mind, this may be central to this appeal. Right? You accept, as my lord put to you a few moments ago, that if you just have the classic commonplace situation where an employer makes a loan to their employee so they can get an annual season ticket, so they can actually get to work, one can see that there is therefore a link to work. It's not completely unrelated to the work relationship. But you accept that that doesn't transform, or doesn't necessarily transform, the nature of the loan into remuneration or earnings for work. So if you then set up a structure by which you put the payment into a third-party trust, and you effectively end up in exactly the same situation, but is it your submission that then means that it's now become earnings?
No, my lord. I mean, I don't think that the mere fact that you've inserted the trust on top, as it were, can make a difference. But it is important to remain focused on the right thing.
Right.
So we are still looking at the question of whether the payment into the trust is earnings. And as I submitted in response to my Lady Justice Falk a moment ago, what happens downstream is analytically irrelevant, although it might educate you about the nature of the payment.
That's why I'm asking the question. If we know that the only reason why it's being done is so that a loan can then be made to the employee so they can buy their season ticket. So if all the facts, as my lord said a moment ago, if all the facts are exactly the same as the commonplace situation, but what's happened is that a trust has been inserted into the arrangement and the payment is in fact made not directly to the employee by way of loan, but is made via the trustee, does that make a difference? Or what, if it doesn't, why doesn't it make a difference?
In those in that factual scenario, it may be that you look at the nature of the loan which comes out and you ask what that tells you about the nature of the payment going in, and you reach the conclusion, well, in that case, it's not earnings going in.
Okay. Well, you see, now in that answer, you've said that you can look at the nature of the loan.
Yes.
And I think that's what the Upper Tribunal is doing here. They're drawing a contrast with Rangers and saying, look at the terms of this loan, and MC has a resulting obligation to repay it. It's not for his entire lifetime, repayable only out of the estate. And so we think that's enough to mean that this remains, if you like, the classic loan to an employee situation rather than earnings for work.
My lord, I accept that the Upper Tribunal is entitled to look at the nature of the loan to educate itself about the nature of the payment going in. I absolutely accept accept that. Where we say that the Upper Tribunal went wrong on the facts is drawing a sharp distinction between this loan and the loans in ranges. Loans in ranges, real loans, subject to an expectation that they would be extended. In this case, loan, real loan, repayable in theory on the 5th anniversary, but Mr. Currell has control over the trustee and the company effectively, so he's in effect in control of whether the loan will be repaid. And so there is no exact parallel with the facts of ranges. I mean, I do accept that the findings in relation to this loan are different from the findings in relation to the loans in ranges.
But the issue was not an issue in ranges. So because it was accepted that the payments were remuneration in ranges, this point about distinguishing the terms of the loan is not really critical, is it?
Well, I suppose you could put it this way, Melody. In ranges, the fact that loans were made didn't prevent there being remuneration.
Indeed, but there were also other things going on in ranges, to which you've responded, including the subtrust arrangement.
Right. So I'm conscious of the time, and obviously the court does have questions for you and for Mr. Ghosh. So we want to make sure that you can finish by 4:15. And I think have you dealt with ground 4?
I've dealt with ground 4, Melody.
Right.
So shall I go on to ground 3?
Please. Thank you.
So now ground 3 sits in a different category from the other ground. This is looking at the question of whether the loan is earnings. I want to say something first about the legal principles, second about how the legal principles apply to the facts of this case, then I'll look briefly at the Upper Tribunal's approach. So in terms of the legal principles, at the outset I think it's helpful to be clear, as I think Mr. Ghosh said, that in a sense there are 2 requirements. You need earnings and you need a payment of earnings. So those requirements are often expressed compendiously. So in ranges, paragraph 8, Lord Hodge said, the central concept of the tax regime governing employment income is the payment of emoluments or earnings derived from employment. So payment of earnings, that's how you put it. But analytically, you can make a distinction between earnings and payment.
Sorry, which paragraph was that? 8?
So that was paragraph 8 of
Okay.
ranges, where you see that compendious requirement. Well, Mr. Ghosh showed you the provisions of ITPA, and there are also the PAYE regulations, which have a concept of earnings, but then the tax charge bites when you have a payment. It says receipt, but then that is effectively translated into payment. So the question which arises under ground 3 is really concerned with the question of whether the making of a loan can be the payment of earnings. So, in other words, if the 800,000 was Mr. Currell's earnings, can one still say that there was a payment of those earnings in circumstances in which what he got was a loan? So we have the source question: is this money from his work as a director? That tells us whether it's earnings. And we have the payment question: has the money been paid to him? And the question which I'm really looking at now is whether a loan can be a payment of earnings. I want to set out what I say are the legal principles in this area and then go on to look at the authorities. So there are 4 points here on the legal principles. First, where a loan is made to an employee that can constitute a payment of earnings. And I want to be clear that I'm talking about something which is a real loan and that it answers to the legal definition of the loan. I'm not talking about sham general loans. Point 2. Whether a loan in fact constitutes a payment of earnings will depend on the facts, which of course have to be viewed realistically. Point 3. If a loan functions in such a way as to place money unreservedly at the disposal of the employee or to give him practical control over it, that will constitute a payment of earnings. And I want to be clear here, I'm not just talking, Lord Justice Foxton asked me earlier about the fact that anybody who's received a loan
control of the right to demand repayment.
absolutely no. So I'm not just talking about unreserved disposal over the money that has been lent to me by my bank. I'm talking about effectively the repayment. So if the facts are such that the loan has functioned so as to make money available, make the principal available to the employee, then it can constitute a payment of earnings. So an example of the kind of scenario in which a loan would function in this way would be where, on a realistic view of the facts, the employee has an option as to whether to repay them.
Do you say that those are the realistic facts of this case?
Well, I'm not sure I would put it in quite such stark terms, my lord, but well, I've made the point already in what I said under ground 4. We do say that the facts found by the FTT show that Mr. Currell had very considerable control over this entire situation.
I think we know that the factual findings you rely on. I think the issue for us is actually whether they went far enough for you.
Yes, I think that probably is the key question. Just to take a step back, on ground 3 there's a kind of high-level question of principle. Can a loan be a permanent payment of earnings? And I understand that is important for my clients, because what we don't want is an absolute rule of law that a loan can never be a payment of earnings, because that creates obvious problems. There's then a question of whether, in this case, we've got the facts that we need to enable you to conclude that this loan was a payment of earnings. And, we've got the facts that we've got. I obviously point to the ones that we rely on for the court to decide whether that gives us enough.
But the fact that a loan is interest free and that you have access to that funding for a long time, let's say 5 years, are you saying that that is enough to mean that it falls into your principle? I don't think you are going that far.
No, my lord, no, I wouldn't make that submission.
No.
Because then how long is long enough? And,
Yeah,
and
yeah.
obviously that gets us into difficult territories.
So it's more your submission, if I understood it correctly, was that where viewing the facts realistically, the borrower of the money in effect has an option whether to repay.
Absolutely.
Do you even go that far? Because that would suggest that any loan from a company controlled by the borrower would be earnings if that person was a director or employee, which is not my understanding of the revenues general approach. So I may I I understand that your clients are very keen to establish the principle of sort of never say never, as in a loan can be earnings. But I'm not understanding you to be putting forward any clear guidelines about where that dividing line is.
Well,
And the ability to control whether to repay, I'm not sure you're saying that's enough. I don't believe you are saying that's necessarily.
well, it's important to remember that you've also got to satisfy the source requirement. So the money has to be earned. So it has to be attributable to the employee's work. This is not just a link or connection. So that operates as a sort of limiting factor. Now, if you've got an amount of money which is the employee's earnings, and the employee has control, well, maybe I can put it this way, maybe. The loan is not functioning as a loan, it is functioning as a way of making money, making that money, which we know is earnings, available to the employee.
Yes, that's another way of saying, in a sort of Ramsey realistic view of the facts, this is earnings. This isn't realistically a loan.
It's not functioning as a loan. It is a loan. Because
Not,
we're not saying
but not realistically behaving like
it's not
one.
behaving like a loan. Yes. You of course have to have earnings. So I want to be really careful with this idea that the moment a company makes a loan of any money to an employee, where in circumstances where the employee is in control of the company, you're going to have a situation where the revenue is saying, oh, that's a payment of earnings. Because you've got to be earnings.
Well, as I'm sure you appreciate, that will often be a very difficult issue, which is indeed why we're here.
It will be a difficult issue it's actually a more difficult issue in some of these other cases that Mr. Ghosh referred to, like CIA and so on, where you've got someone where there's a real debate, is this a distribution of earnings? In this case, this is actually simpler because we don't have that today. The only reason that it was identified is Mr. Currell.
Right. Was that point 3 of 4?
That was point 3 of 4.
Yep.
So point 4 of 4. I think I've covered this. It's not HMRC's position that all or most loans amount to payments for the purposes of the relevant provisions. And if that is what the FTT was saying at paragraph 37, then we don't defend that conclusion. That conclusion, if it was right, would of course, as Mr. Elliott says, effectively render pointless all of the provisions that we've got in the tax code about the taxation of loans. But that's not our position. So I want to consider now the authorities to try to make those submissions good. The first case is Garforth. I don't think we need to turn this up. I think that the relevant facts we can just take from the headnote. The facts are straightforward. The taxpayer company awarded bonuses to the 2 directors. An element of those bonuses was paid in cash, and the remainder was credited to their loan accounts with the company, and the directors were free to draw on those loan accounts. The revenue took the view that there had been a payment of the bonuses by them being credited to the loan accounts, such that the company was obliged to make deductions under the rules as they stood at the time. This was under earlier legislation, but deductions were required where there was a payment of income which was assessable under schedule. So you still have the same basic idea: is there a payment of income against it under schedule? And the question which the court needed to consider was whether the crediting of the two directors' current accounts with their bonuses was equivalent to payment or not. And if you know, that's page 565 of the authorities' budget. And what Mr. Justice Walton said was that when money is placed unreservedly at the disposal of directors by a company, that is equivalent to payment. So that's page 567 of the authorities. So Garforth is the source of the proposition that where money is placed unreservedly at the disposal of an employee, that amounts to payment for the purposes of the charge to tax on employment income. Now, I of course accept that Garforth was looking at the question of whether there was a payment. It was not concerned with the question of whether the bonuses were earnings, whether they were referable to the directors' work as directors. It seems to have been common ground that they were. So that was a case where it was clear that you had earnings, and the question was, is the crediting of the amount to their loan accounts good enough to amount to a payment of those earnings? So of course, Garforth doesn't mean that in any case in which a company puts money unreservedly at the disposal of an employee, there will be an employment income tax charge. It's still necessary to decide whether you've got earnings. But if you have got earnings, what we know from Garforth is that if the money is put unreservedly at the disposal of the employee, that is good enough for there to be a payment of earnings and so trigger the obligation to deduct it. The next case is one which Mr. Ghosh mentioned, Aberdeen. This is at page 734 of the authorities. It's divided 28. Again, the scheme is described at paragraphs 12 to 14. And I'll just outline the steps. So an EBT was established and funded. The trustees of the EBT incorporated money box companies for each relevant employee and subscribed for a share at a substantial premium. There was then a step designed to dilute the value of those shares, and following that, the money box company was transferred to a nominee for the employee in question, and the employee could then access the funds in the company by means either of a loan or by using property acquired by the company, so various ways in which the employee could access them. So in the inner house, the key relevant question was identified in paragraph 25. This is on page 747. So the critical question, this is the beginning of 25, the critical question raised by the Ramsey cash box issue is whether the transfer of shares to an employee was a payment within the meaning of section 203 of this was ICTA 1988. And Lord Drummond Young proceeded to discuss the familiar Ramsey principles, and this goes up to paragraph 32, and then his analysis begins at 33 on page 751. So at the beginning of 33, he says, I'm clearly of the opinion that the transfer of shares in a money box company to an employee was a payment. And he discusses the concept of payment in particular paragraph 34. The second sentence of 34, he says, in practical terms, therefore, the crucial question is whether funds have been placed in a position where, as a practical matter, they may be spent by the employee as he wishes. And then towards the end of that paragraph, it talks about practical control over the disposal of the funds. So, there are 2 points which I want to note at this point. The first is that Lord Drummond-Young did not stick precisely to Mr. Justice Wilson's unreservedly at the disposal of formulation in Garfield. We seem to be looking at a broader test of practical control. The second point I want to make at this stage is that Aberdeen was a case in which it was clear that the money was earnings. So like in Garfield, the money was earnings. The question was whether this scheme was good enough to amount to payment. So what we get from Aberdeen is the proposition that if an amount is earnings and it is then put in the practical control of the employee, then it will have been paid and the obligation to deduct and so on follows. Now next, I want to look at tough days. This is the case which we handed up this morning. Sorry, it's not in the bundle. It's actually called, the report is called Oco Limited. There was another part of it which was called Tough Days, which is...
Has it been sent electronically? If not, could it be, please?
It hasn't, my lady, don't really know.
Thank you.
Thank you.
So this is only a decision of the first tier tribunal, but we say that it's helpful in relation to ground 3 because it provides an example of a case in which the FTT thought that the making of a loan to an employee could be regarded as a payment of earnings to him. The facts are set out in the head note. I'll just, given the time, I'll just identify the key points, unless the court would prefer to read it in full.
No, that's fine.
So the key facts. The taxpayers wished to establish a flexible means of providing benefits to key employees. The taxpayer companies established and funded an EBT. The trustees created sub-funds for the benefit of the relevant employees and families, and benefits were then provided in various ways, mainly by the trustees advancing loans to the employees. And the overall question was whether the funds in question were taxable as earnings. HMRC relied on various arguments. This was obviously decided before the Rangers Supreme Court. So first, HMRC relied on a redirection argument. So this was that the amounts were earnings before they entered the EBT. The FTT considered this issue from paragraph 247 and decided that the sums were not earnings before they entered the EBT, essentially because the directors did not at that stage have any kind of entitlement to them. That's what the FTT says in paragraph 250. And also, it's worth just noting paragraph 185(2) identifies this need for entitlement. Now, of course, we take issue with that view under our ground too, but that's what the FTT thought. you need to have some kind of entitlement. There was no entitlement before the money in the EBT, so HMRC's redirection argument fails. So, for the purposes of ground 3, the key point is that you don't have earnings going into the trust. HMRC's next argument was that the amounts contributed to the sub-trusts were earnings on a Ramsey analysis, and the FTT ultimately agreed with HMRC on that. So that conclusion is paragraph 333. So that was enough for HMRC to win the case. But in case HMRC hadn't won on that one, its next argument is that the loans were earnings. So the FTT didn't need to determine that given its conclusion on the sub-trust issue. But it nevertheless addressed it at paragraphs 337 to 346. And it's that part of the decision which is relevant for my ground 3 purposes. So obviously overturned, but please say this is still helpful. So there were 2 aspects to HMRC's argument that the loans were earnings. First, HMRC argued that the true agreement was that the loans were not really loans. And that argument is summarised at 338. The FTT rejected that argument at 341. So the FTT said, I'm not satisfied that there is sufficient evidence that true agreement between trustees and directors was that there was not a loan. And in rejecting that argument, the FTT in 341 attach particular importance to evidence showing that the directors understood that the money might need to be repaid and that they had an ability to repay. So those are important findings in 341. This is jumping ahead a little bit, but there's a clear echo with the findings in this case that Mr. Currell understood that he would need to repay, might need to repay the loan, and that he had the resources to do so. So, FTT rejects the argument that the loan is not really a loan. We're not making that argument in this case. Had we made such an argument, no doubt it would have been rejected for the same reasons as it was in Tough Case. But then the second aspect of HMRC's argument in Tough Case was that the loans were earnings based on a Ramsey analysis. And so HMRC invited the tribunal to find that on a realistic view, it was never intended that the trustee would exercise their right to demand repayment of the sums, and the sums advanced were earnings. So that's 337. Right, halfway down 337, you have HMRC's alternative argument on this point. And on this point, the tribunal agreed with HMRC. So the key passage starts at 344. In that paragraph, the tribunal said that on a realistic appraisal, the situation was one in which the borrower had an option as to whether to repay the loan. So the situation is essentially one where A transfers money to B on the basis that B will be liable to pay the money if B determines it's in his interests to do so. And on that basis, the tribunal concluded at 346 that if there were not earnings when the funds were appointed to the subtrusts, obviously it had found that there were earnings when the money did go on to the subtrusts, but if it was wrong about that, there would be a payment of earnings when the loans were. And the test which the FTT seems to have applied, you can see in 344, the end of 344, says in circumstances such as these, the money is for all practical purposes money which is at B's disposal. And again, I'm sorry, picking up my Lord Justice Foxton's point, it's clearly talking about more than just having the proceeds of the loan from the time being. It's talking about the ability to
It's really an application of Ramsey.
absolutely, it's an
So
absolute.
could it be said that's really an extreme case
Well, my Lord, not really. I mean,
in the context of a loan?
I'm sorry, Lord.
In the context of a loan, could it be said that that's an extreme case? Because it's effectively saying that for all practical purposes, although it's not a sham, so it is a real loan. Because if it weren't, then you don't even get into this question. Is that right?
Sorry, if it was a sham, then it would be, of course, it would be different.
Exactly. So we're dealing with that relatively narrow terrain where you have a genuine loan, which is not a sham, but nevertheless, for all practical purposes, the money is at B's disposal, applying Ramsey.
Yes.
Now, I'm not, to me at least, that looks like an extreme case. That's not a run-of-the-mill kind of loan.
Well, it might be a rare case in the sense that it wouldn't be a run-of-the-mill loan. I think we would accept that.
Yes.
But the facts of this case show that this is not a particularly strange
Right.
or outlandish example. We've got a conclusion that there are real loans. The directors acknowledge that they have an obligation to repay. They have the money to repay. But in these circumstances, the tribunal is able to conclude that, viewed realistically, this loan is not functioning as a loan. It's making money available, and so constitutes a payment of loans.
I see. Thank you. Right.
I've looked at the draft grades in a little bit of detail because it gives us something beyond what we know from Garforth and Aberdeen. Those cases were cases, as I said, where it was obvious that there was remuneration, and we're just looking at the benefits aspect of the question. In Toughglaze, you didn't have that agreement that there was a payment of remuneration. You didn't have that agreement that there was remuneration. I think I'm right in saying that. So what the tribunal said, which is important for our purposes, is that you had a payment of earnings in circumstances where you hadn't already identified earnings. Obviously, in fact, the FTT had decided that the appointment under subtrust was earnings, but if it hadn't, or if it was wrong. I'm conscious of the time, so I just want briefly to say something about the application of the principles to the facts of this case. So my overall submission is that it's apparent that the FTT concluded in this case that the arrangements gave Mr. Currell practical control over the funds. And the source of the funds was his work as a director of the Respondent. We've identified several times now the findings which we rely on to say that Mr. Currell had practical control. I absolutely accept that the FTT did not in terms find that he had a kind of option as to whether to repay. But it is possible, taking a fair view of the findings which it did make, to conclude that he had very extensive control. We've also, or Mr. Ghosh has also shown you the findings which the FTT made, which show that the source of the money was Mr. Currell's work. So again, you need to join a few dots here. You have to look at the FTT's findings as to why the loan was made, the FTT's findings as to why the payment was made. In summary, it says the loan was made because his work. That was the only
Yeah.
reason.
And you've
Payment-
given us, just to be absolutely clear, the paragraph numbers in this submissions of the facts. Those are the paragraphs on which you rely and which we should look for this.
That's right, my
conclusion.
lady. Of course, the court will look at the entire decision, but
Indeed.
those are,
I just want to understand your
yes,
argument.
yes, those are
Thank you.
the factual findings on which we particularly rely. So where this takes us is that if we're wrong on our primary case being that the FTT found that the payment was earnings and it was entitled to find that, and if in fact the FTT found that the loan was a payment of earnings, then that was the conclusion which it was entitled to reach. Now, looking very briefly at the Upper Tribunal decision, the Upper Tribunal said, paragraph 90, that Parliament cannot have intended that any or the vast majority of loans by an employing company to an employee would constitute taxable earnings. Now, we say there's a lack of clarity as to what exactly the Upper Tribunal was saying. If it was saying that a loan can never constitute a payment of earnings, we say that's wrong in light of the authorities which I've shown you. And that is an important point that is very important to know. If what the Upper Tribunal was saying is that, okay, perhaps a loan can be, in some circumstances, a payment of earnings, but it wasn't in this case, then we don't disagree with the Upper Tribunal as a matter of principle, i.e. that most loans won't be earnings, but a loan could be a payment of earnings. But we say that the Upper Tribunal went wrong in its analysis of the FTT's findings of fact. And essentially we say that the Upper Tribunal mischaracterised the findings which the FTT made. I think I've covered all the, or we have covered all the various factual points between us. Now then there's this final point I think that I want to make. In the Respondent's skeleton argument, they say that HMRC needs leave to take what is characterised as a viewpoint, i.e. the view that the loan was earnings. I just want to make sure the court is clear on this. It's correct that we did not argue in the first tier tribunal that the loan was earnings. That was not our case. And our primary case is that that is not what the FTT decided. But if that is what the FTT decided, then we defended that in the Upper Tribunal as an alternative case, and we still defend it in this court as an alternative case. So the point was certainly run in the Upper Tribunal, and can't sensibly be regarded as a new point in this court. And in any event, we're not asking for any further findings point concerning the legal analysis, and so if we do isolation.
And you've been given permission to appeal, but there's reliance placed on some case law which says that doesn't mean that you're entitled to argue it anyway.
Yes, yes.
So speaking for myself, I find it's all quite odd, but we'll hear what the respondent has to say about it.
Yes, that's my understanding of the point. I also found it slightly surprising.
I can understand it. There's more recent learning in this court. Certainly since I've been a member of this court, we've had a number of decisions where the point has been emphasised that you can't raise a point of law in this court which you've not raised below, particularly in circumstances where it might call for fresh evidence, for example, or further findings of fact to be made. But generally speaking, of course I'll hear anything the respondent wishes to say to us tomorrow. Generally speaking, this court takes the view that we're here to get the law right.
Absolutely.
I mean, if it assists, we're entirely in the hands of the court.
Very
On
good.
this point, we've heard full argument. I'm ready to respond in full, so completely in the hands of the court.
That's
on
very
that.
helpful, thank you.
If you look at it, I don't think I need to say anything more about
I'll
it.
just check if my lady has any questions for you. Oh, my lord. Well, I'm very grateful both to Mr. Ghosh and to you. Sorry, Mr. Ghosh.
I've got 2 minutes. I've got 2 minutes just to make 2 points, because
Yes.
you raised 2 questions with Mr. Waldegrave that actually are relevant to my ground too, and it's appropriate to respond to that, to those. One, my Lady Justice Falk, said, well, look, nobody really cared very much in Rangers about the loans by then, because of course it was remuneration, and that's something we've heard over and over again in submissions here. And Mr. Waldegrave's response correctly was, yes, we needed to look at the loans in order to find out the character of the payment, because we're fighting about that issue. That's it. So it's not right to say that the loans are central in any analytic way. In this case, they are in a way that they weren't in Rangers. That's not right. Second, well, if that's true, we're looking at the loans. Of course, we have to look at the all the characteristics of the loan, including the fact that they have genuine obligations. And about that, because Mr. Waldegrave's responses to questions from the court on ground 3 are also relevant to my ground 2. On that, we have a world in which not only is it controversial whether it was the only thing stopping repayment in 5 years was the prospect of double tax, and I said, even if it was, I don't care. Also relevant is the factual background that apart from that 50,000, nothing has been repaid. And then, that's my first point, that's relevant. And it wasn't addressed at all in paragraph 130 or 131 of the Upper Tribunal. The second point I want to make is the point made by my Lord Justice Foxton, which is, and this is the burden of the question. Look, if you make a season ticket loan, that's linked to your employment. If you make a season ticket loan via an EBT, that doesn't change it into earning. I'm not saying it does. What was bought with this £800,000 was unfettered access indefinitely. There's no 5-year gap in that. To money to be extracted tax-free from the companies. This isn't a season ticket loan. Not at all. For somebody who has hitherto been unrewarded for what is work. So it's not a season ticket loan made via an EBT. And so the worst you can say, the worst thing they've done is route a season ticket loan through an EBT. No. They've paid money in order to let Mr. Currell have it, in order to get him to buy something, let him buy something, which is unfettered access to that 800,000. And that is
That's very helpful.
that's a lot.
In the meantime, I noticed that somebody has kindly emailed us the Tufclay's decision electronically.
Oh, I'm very grateful to those men. Thank you.
That's all very helpful. And Mr. Elliott, we will, unless you want to say anything now, we look forward to hearing you at 10:30.
They have now run down the clock to 1 minute to go. Unless there's any points I can deal with, unless the district court
And
has
I
any
think
questions before we kick off. I
We'll
will
start with you at
tomorrow.
10:30 tomorrow morning. Thank you.
Court rise if able.